Hi, I'm Hani Bushra. I'm an immigration attorney in Huntington Beach, California. This is a video about the ruling in case of Casa de Maryland versus Wolf. It's the case that challenged the new work permit rules that were issued on August 21st and August 25th. I'm going to discuss these rules and give you some tips about the ruling that happened and the judgment and how you could probably benefit from it, even though that it's kind of limited right now. I just want to say that today's date is September 14, 2020, because things keep changing all the time with this administration, and sometimes the videos get dated, and what we give as an advice could change maybe a day later, okay? So today is September 14, 2020. So basically, this is a lawsuit that was brought by 4 organizations. These organizations serve immigrants. They are membership, some of them are membership-based organizations. They are based in the East Coast. One of them is Casa de Maryland, and one of them is, I think, ASA or something like that, that's in New York. They challenged 2 rules that were implemented regarding work permits for asylees, or people who are going to be applying for work permit for asylees. The first rule was the August 21st rule of 2020, August 21st, 2020, that basically removed the limit by which the USCIS immigration can go ahead and process your work permit. So previously, whenever you sent a completed application for a work permit, USCIS had 30 days to process your application. Now, I've been practicing for so long, and I know that most of the time these 30 days were not respected, okay? But it was sort of like a sword that you could use against USCIS if things were delayed excessively. So USCIS decided to remove that rule, not to replace it with an extended period, not to say it's going to take 60 days or 90 days, just said whenever we decide, we decide. So that was the first thing that was challenged in this lawsuit. The second thing that was challenged was the rules that were implemented on August 25th that modified the asylum, the work permit for asylees, people who are pending asylum case. The big ones in that rule are the following. Number 1, that you had to wait 365 days to apply for for a work permit based on your asylum application. Previous to that, you had to wait 150 days, you apply, and it should come back on the 30th day, which means a total of 180 days. So after 6 months, you would be able to get a work permit, and not a whole year. But now you had a whole year to apply, and then there's no time limit on processing your application, which means that it could take forever, okay? So that was the first thing that was in that rule. Number 2, okay, was that it modified these rules on August 25th. It modified that it made it a requirement that you have to do biometrics for your work permit, which would add more cost and more delays as you apply for a work permit. It also modified the fact that if you have been here for more than a year, even if you were in a legal status, but then decided to apply for asylum, okay, you would not be getting a work permit until your asylum case is heard, which can take many, many, many years, okay? It also said that if you tried to come into the country in any other areas other than the port of entries, and then you applied for asylum in the United States, okay, but did not surrender yourself to somebody within 48 hours by the port of entry, you're denied getting a work permit. So these modifications or rules were implemented on August 25th, and these organizations sued against them in early August, but there was a lot of complications going on. There was more briefings or more documents required by the judge, so it took a while for the judge to issue the ruling. The ruling was issued on September 12th or September 13th. It was I read it sometime in midnight, so I'm not sure of the day, but it was over the weekend. So what is the ruling? Number 1, okay, the ruling said that most likely these organizations are going to win their case against the government. And the reason they're going to win their case is that the person who signed these rules or went ahead and implemented these rules was not legally appointed to head the agency of USCIS or Department of Homeland Security. And the reason is that the Department of Homeland Security, the person who was selected by the president, which is Kristen Nielsen, resigned over 500 days ago, okay? And when she resigned, the president should have nominated somebody else for the Senate to go ahead and approve so they can serve in that function. Instead, the president chose to have people who are acting as Secretary of Department of Homeland Security. And when you do that, there's a limit on how much they can stay acting. Before that, after that, whatever they do is deemed illegal. And the idea is to encourage presidents not to have acting secretaries of cabinets or something like that, but it's to encourage them mainly, okay, to go ahead and follow the rule, which is get a name before the Senate and let the Senate give you its consent to the person serving in that capacity or not. And so the judge said, you know what, most likely this rule, okay, is invalid because the person who signed it, or these rules, the August 21st and August 25th, the person who signed it is most likely not legally appointed and therefore cannot issue these rules. Number two, he said the rules are not rational. There's no reason for why these rules. It doesn't make sense why you're extending this time. It doesn't make sense that you're saying you're going to need a whole year to get an asylum application. It doesn't make sense that you are saying I'm going to remove all limits on how long it's going to take me to process my application. It's capricious. It's like somebody woke up with a bad mood and decided to change something, you know, without any rationale. And you can't make rules like that. We're in democracy. You cannot make rules like that. Okay, so the judge decided to enjoin the rule, meaning that he's going to say, I'm going to stop the rule until I hear a full arguments on this case. Now, here's what the problem is. Federal judges, until a year and a half ago, had so much power to enjoin nationwide. All over the country, you can rule and say, you know what, okay, my rule, even though I'm sitting in Baltimore, Maryland, this case was in Baltimore, Maryland, is going to apply to all of the country. So they had that power. The federal judge is a very powerful entity. Okay, the problem is Supreme Court. Okay, over the last year and a half, because of the Trump appointees, has been saying no, federal judges don't have that power on a nationwide injunctions, except in certain restricted times. They have limited power to certain enjoyments to certain people who are before them in certain areas. Okay. So the Supreme Court has been striking nationwide injunctions, and lower courts, which is the Court of Appeals, which lead to the Supreme Court, have been doing the same. So this judge said, you know what, I am not going to go into a fight on whether I'm going to implement a rule that can be accepted or not accepted, okay, nationwide, or I'm going to stop a rule that's going to be accepted, or my stop is going to be accepted nationwide or not. What I'm going to do is I'm going to limit my rule to the members of the 4 organizations, okay? So Casa de Maryland and the rest of the organizations. And he stopped the rule in regards to certain things, not to everything, but in certain things only, okay? And again, those are for the members of Casa de Maryland. So number one, he said the judge repealed the timeline rule, which is that he said there is a limit to how long you can take to process an AAD or an employment authorization document, which is your work permit. Number two, he said the 365 days has to be stopped. We go back to 180 days, basically. He said once an application is filed and accepted for filing, it's considered complete by USCIS. I don't need to get a new letter from USCIS to say it's complete. He said that the 1-year filing deadline bar, which said that if you were here for more than a year, even if you were here legally but then applied for asylum, is not going to be applicable. And he said there is no requirement to put biometrics at all on the work permit. Now, these repeals or these injunctions to remove or to stop the application of these rules are only for the members of the organizations. Okay, but here's the thing that you got to understand about the ruling. Okay, number one, the judge did not say that the members of the organization had to exist before his ruling. So what that means is that if you are somebody who become a member of this organization after the ruling, you would be covered by that ruling. Okay. Now, there is an organization indoor, which is Casa de Maryland, that has a paid membership. You can go to their office in Maryland, okay? You can file an application. You don't have to be living in Maryland. You don't have to be living in a certain geographical area. You can file an application, pay a fee, $35, plus $5 to get an ID. Get an ID. Be a member of this organization. It's an organization that gives information about immigration, about cases, about stuff like that. It's a non-profit organization, a great organization that I donate to. You can become a member there, and then you'll be part of that class, okay, of people who are covered by this injunction, okay? So that's one thing that you might want to think about. I'm going to put a link to the organization in the description here that you can go ahead, okay, and click on it and follow the directions on how to become a member. Now, please bear in mind, this is just my reading of the rules right now. We don't know how USCIS is going to react. Is USCIS going to say, okay, you know what? Yes, I'm going to have 2 separate groups. I'm going to have a group that is covered by the Casa de Maryland case, and I'm going to treat them differently. And I'm going to treat the rest of the people who are not covered by that case in a separate way. We don't know if there's other lawyers who are going to file suits in a different state or something like that, and say, you know what, there's a judge that decided this in Maryland, why don't we decide it in our states? So we don't know how it's going to be implemented, okay? We don't know if USCIS maybe will take the stand and say, you know what, I'm going to stop the rule for now until I figure out what's going on with the case. We don't know if it's going to, if the government is going to go ahead and appeal on that rule, and then a circuit court or an appeals court will stop the injunction that the judge put. So put a stop to the stop that the judge put, okay? We don't know if that's going to happen. But as of now, I think a wise decision would be to become a member of one of those organizations, okay? Have a proof of that membership, and then if you have passed 150 days in which you're eligible to apply for your work permit, okay, you would apply, okay? And so I think that's a good idea, or I think it's something that is a way that could help people who are stuck or who are surprised by the change of rules and something like that, okay? So, I appreciate that you are with me in this video. I'll try to update as much as possible about what's going on in this case. There's twists and turns that could happen, but I think it's a good ruling, a ruling that is positive, because it could give encouragement to a lot of other organizations to go ahead and sue in different locations and maybe get a similar injunction for their cases. Thank you again. My name is Hani Bushra, and I hope to see you in the next video. Thank you. Bye-bye.